All the phones are switched off? No?
You mean like sound?
Sorry, silent.
Okay. No deal.
Good afternoon, everybody. Welcome. My name is Brian Roche. With me are the inquirers, Mike Heron, KC, Pania Gray. I thought Mr Heron and Pania would make some opening remarks and then I'll say a few words. After that, I'm really happy to take questions. But before I hand over to Pania and Mike for context, I want to say something about the scope of the inquiry. The Commission's jurisdiction and my jurisdiction covers the public service and public servants. The inquiry did not independently assess the conduct or make findings against third parties. Legislation limits the Commission's scope to public service agencies. The inquirers heard serious allegations that go to the integrity of our democratic process. Those matters, because they were outside the scope of our inquiry, have been referred to the appropriate authorities, namely the Police and Privacy Commissioner, who have the legislated, regulatory and investigative tools to consider them. I'll now ask Pania and Mike to say a few words.
Kia ora. Before Mike and I summarise the key findings and conclusions, I will recap the background to the inquiry quickly. The inquiry concerns allegations reported in the media in June 2024 that personal information provided either by or to government agencies for COVID-19 vaccination purposes or the 2023 census were used for improper purposes by certain service providers. The agencies that we were asked to inquire into were Te Puni Kōkiri, the Ministry of Health, Te Whatuora Health New Zealand, Statistics New Zealand, the Ministry of Social Development and Oranga Tamariki. The three providers were Te Pou Matakana, also known as the Whānau Water Commissioning Agency or WACA, Manurewa Marae Trust Board and the Whānau Waipareta Trust. Our task was to establish the facts and make an independent assessment of government agencies' activities in relation to the allegations within our scope. There were two ways that personal information was shared for COVID-19 vaccination purposes: controlled access to the national immunisation databases and formal data sharing agreements. We were satisfied that the safeguards and institutional arrangements in place for the service providers' staff accessing the COVID-19 immunisation registers were both adequate and effective. There was extensive training, multi-factor authentication and regular surveillance for unusual activity operating. Personal information on those databases cannot be downloaded or transferred. The Ministry of Health and then Te Whatuora entered into a number of data sharing agreements or DSAs with Te Pou Matakana. In short, we were satisfied that the terms of those DSAs laid strong foundations for the protection of personal health information shared for COVID-19 vaccination purposes. While the front-end safeguards were adequate and appropriate, the back-end safeguards were lacking. There was limited checking that those foundation safeguards were being met, and we found that there was a lack of controls once the data was downloaded by providers. Further, neither the Ministry of Health nor Te Whatuora have a facility to audit the provider's use of the data. This meant that the parties relied on trust that the DSA terms were being complied with. We do not consider this to be appropriate. Te Whatuora told us that it intends to fix these shortcomings in its standard DSA terms. At the time we carried out our inquiries, Te Whatuora had not yet obtained satisfactory assurance that Te Pou Matakana and Waipareta had complied with all of the obligations that sat across the data sharing arrangements. We record that this is unsatisfactory as it meant that we could not conclude on how effective the safeguards and institutional arrangements have been. We note that Te Whatuora stopped sharing data with Te Pou Matakana in June 2024. We also note in our report that Te Whatuora was satisfied that Manurewa Marae had complied with its obligations. We found that there were no safeguards in place for either the Ministry or Te Whatu Ora to identify or manage possible conflicts of interest in relation to these data sharing arrangements. Both agencies have accepted our findings, and Te Whatu Ora has, as the lead agency for health data sharing, advised us that it will revise the DSA terms to provide for the active consideration of conflicts of interest. Our inquiry found that there was no evidence that either the Ministry or Te Whatu Ora were made aware of the allegations within our scope prior to the June 2024 media reporting. I'll hand over to Mike.
Thanks, Pania. In relation to stats and the Census 2023, stats shared data for non-responding households with Te Pou Matakana. The information was shared under an information sharing agreement. Concerns about the management of personal information were raised with stats, both internally and externally, including while the contract was being performed. The complaints raised by stats employees were largely ignored. Stats dealt with the external concerns as best it could. The safeguards and institutional arrangements we found in relation to protection of personal information were insufficient for several reasons. The first is that stats provided information to Te Pou Matakana before it understood how it would be dealt with, handled, protected and destroyed. Stats removed the requirement for certificates of confidentiality, which is a key requirement to ensure the protection of census data. Stats did not finalise a privacy assessment, a privacy impact assessment that is, and drafts we've seen show confusion about the management of information. Stats did not provide adequate training, and the training materials that Te Pou Matakana provided raised red flags as to how information was to be protected and or used. The conflict of interest terms in the contract only considered conflicts arising from Te Pou Matakana. It didn't expressly provide for conflicts arising from subcontractors such as Manarewa Marae. That risk was raised early in the process by a stats employee. But in any event, neither party to the contract seems to have considered the conflicts of interest provisions, and possible conflicting interests were not identified or managed. We find the aim of the stats contract with Te Pou Matakana was well-intentioned, and the resulting additional census forms meant that stats considered the contract was successful. However, the stats processes meant there was a risk of the mishandling of personal information which was not addressed, and as a result there was a risk of the collection or use of personal information for an improper purpose. In respect of Te Puni Kōkiri, Ministry for Social Development and Oranga Tamariki, none of these agencies were providing personal information within the scope of the inquiry. Neither Te Puni Kōkiri nor Oranga Tamariki management were aware of the allegations, and there's insufficient evidence for us to conclude whether MSD management were notified of these allegations before they became public. Just finally from me, two observations we make in the report, that the protections for personal information existing in agreements or contracts are just only one part of the overall protections required. The ability to monitor, audit and hold accountable relevant contractual parties is also important. And following from that, when concerns were surfaced publicly by the media about the relevant service providers using personal information for improper purposes, those providers all swiftly refuted the allegations. However, we find that none of the agencies were able to draw on their existing assurance systems to respond to the allegations, and that we say is problematic. Back to you, Pania. Thanks.
The inquiry terms enable us to make referrals to other agencies, and we've made a number of referrals to the Privacy Commissioner for his consideration. The first relates to a lack of systematic means for agencies to assure themselves that the relevant service providers were meeting all relevant privacy protections. The second related to the absence of underlying systems and controls for the storage, use and disposal of data after transmission through secure systems from the agencies to the relevant service providers. Third, alleged unauthorised use of personal information collected for COVID-19 vaccination purposes or at the point of COVID-19 vaccination. And finally, how privacy obligations were met by the providers during the collection of census data. Our terms of reference required us to establish the facts and to form a view on government agencies' activity, not to reach a conclusion about whether providers used personal information for an improper purpose. We note that some of these matters are subject to the police investigation. There were also two employment-related matters which came to our attention during the inquiry, and as they were out of scope, we referred these back to the agencies concerned. Brian.
Thank you, Mike and Pania. The public service has a duty to protect the personal information of New Zealanders. That is a non-negotiable value. This inquiry has found some agencies failed in their responsibility to protect and manage the sharing of personal information. While we don't know if personal information was improperly used, the opportunity was left open, which is unacceptable. As I've said, it will be for other authorities with the appropriate regulatory and investigative tools to determine whether personal data was misused. Regardless of what those authorities find, New Zealanders rightfully expect government agencies will protect and manage their personal information, and that didn't happen, which is unacceptable. In my view, the report makes for very sobering reading. It raises a number of issues that go to the core of the confidence and trust required to maintain the integrity and sanctity of information entrusted to government agencies. The system has failed, and that isn't acceptable, and it must be and will be remedied. As we enter a rapidly changing world where data and information is a key asset, we need stronger processes around the use of information. That work is underway with a view to it being applied across the public sector. Stats New Zealand failed to address a significant risk of mishandling of personal information it collected for the purposes of the census, even when concerns were raised internally. This was unacceptable. Given the findings of the report and recognising the need for accountability, the Chief Executive of Stats New Zealand has advised me he will not be seeking reappointment. I think it's the right thing to do in the circumstances, and I respect Mr Soudan for what would have been a tough decision. Mark's decision to step down reflects positively on his professionalism and his integrity, which is in line with the standards of accountability I expect of public service chief executives. The inquiry also found the Ministry of Health and Health New Zealand Te Whatu Ora had insufficient safeguards for managing conflicts of interest arising from the sharing of personal health information with the relevant service providers. While this is less serious, it fell short of our own standards and expectations. There are lessons here for the public service which we need to get right for the future. Clearly, we need to raise the bar. As the result of the findings of this inquiry, I have taken a number of actions to help restore public trust and confidence. I have asked agencies with inquiry findings against them to immediately suspend, on a temporary basis, the renewal, extending or entering into new contracts with third-party providers named in the report until those agencies can satisfy me that their contracts are fit for purpose and adequately deal with the information sharing and conflict of interest obligations. It is my intention that by 1 July, All new information sharing agreements between the public service and any third parties must comply with the new information sharing standards. Secondly, we are updating guidance and templates for information sharing arrangements. We are strengthening public service procurement practices to reflect the new standards. We have reviewed and updated the Commission's conflict of interest model standards. This means all third-party providers who enter into agreement with core public service agencies will also need to meet the obligations around conflict of interest and sharing of personal information. This will strengthen accountability settings for all public service agencies when contracting and information sharing with third-party service providers. I have also asked the Ministry of Justice to consider whether changes are needed to electoral law regarding financial incentives to switch electoral rolls. In addition, and as Pania noted earlier, the inquiry leads have made a referral to the Office of the Privacy Commissioner. The police are looking at other matters. We are very happy to take any questions you may have of us.
So Brian, how can anyone have faith that their personal data will be protected given this report?
I think they've got every reason to have confidence. One of the benefits of this report is it's been a massive wake-up call for us. We have remedied it and we are in the process of further strengthening it. So I would like to think this is an isolated incident, but the consequences of it are far-reaching.
We've specifically focused on Manuela Marae here, or you have in this report. Is there any concern from your end that this is more widespread than just that one area?
There is no concern, but we can't be complacent, which is why I want a whole system response, because it's happened once. We have to be assured it cannot and will not happen again.
Did it surprise you that there were no, that last recommendation that you made regarding a law change around incentives to change electoral rolls? Did it surprise you that there was nothing to cover that?
I'm surprised by a lot in this report. That is a matter for someone else to determine what, if any, actions are required.
And you're about as close as it comes to the most experienced member of the public service, and you've had significant dealings in the private sector as well. Where does this sit in the scale of failures that you've overseen or that you've investigated or just frankly have looked into in your long career?
As I've said, I found this a very sobering report. I think it is a massive wake-up call, and it's on the verge of the digitisation of services and greater use of technology. There has to be a non-negotiable sense of confidence the public must have in us as the public service. And this has shown a systemic failure in one agency. That is one agency too many.
Can you talk a little bit more about the safeguards that Stats NZ did have in place and why you believe that those were insufficient?
Mike, are you...
Sure. Well, the contractual safeguards were the orthodox ones, but in terms of the ability to monitor, audit, to get confirmation, and in terms of the actual follow-up on conflicts, they just didn't happen. And as we know, things like training, things like the checking of what was actually happening on the ground, it didn't happen, and they weren't able to gain assurance after the fact.
So there was no follow-up. That's effectively what you're saying. So there were contracts that were put in place. There was an expectation, and then there was no real follow-up from Stats NZ.
Well, limited effective follow-up.
Were you shocked by, there's some real specific failures in here, for example, not having that certificate of confidentiality. Were you shocked that Stats NZ staff just went ahead and removed that certificate without consulting with the government statistician? And also with regards to the point about ignoring some of those internal staff concerns, what was happening within Stats NZ?
Well, shall I take that?
Yeah, absolutely.
I mean, whether I'm shocked or not is probably irrelevant. And as Brian said, we all get surprised by things. In the certificates of confidentiality was slightly more complex. Those who were dealing with it didn't truly understand the requirement and misunderstood what they were saying was was waived, or if you know what I mean. So there was a communication breakdown, there was a knowledge breakdown, and ultimately that led to an understanding that it was waived, and unfortunately that was a serious result.
So would there be greater training for those staff?
Yeah.
Oh, yeah, of course. Yeah.
Can I just make, before we carry to Andrew, the issue actually is the stats department had very good processes which would have provided what was required. They failed to follow their own processes.
During the vaccination...
Can I just, sorry.
I just wondered, there were a number of occasions where there was an opportunity to step in and stop this, raised both externally and internally, and with the Electoral Commission. I think the phrase that Mr. Hearn used was it was well intentioned. Was there a culture within the agencies that what they were trying to achieve justified the means, the ends justified the means?
There is a sense that their sense of urgency overtook good process, and at one level that's understandable, but there are minimum standards that even with speed that you have to comply with, and they failed to do that. Hence this review and why we're making the changes.
Just on the health data side of things, there's a line here about the fact that Te Whatu Ora couldn't follow up and see what happened with files after the information after it was downloaded. It says, it appears to us that this is not unique to the information sharing arrangements with Te Pou Matakana for COVID-19 vaccination purposes. Is this standard practice in health information sharing, the agencies not having any ability to follow up on that information afterwards?
In relation to that method of sharing data over that SFTP pipe, apologies for the acronym, that does seem to be the case.
And how?
So,
sorry.
So the transmission line, we were confident was a very secure method, but there is a lack of controls once it's been receipted by the third-party service provider. Once it's downloaded, there is a lack of controls.
And how widespread is that technique for sharing it?
As we understand it, it's a very common way of sharing data.
Speaking to Andrea's question, is there potential in the future that this kind of pressure is not put on agencies, in order to collect that census data in the way that they've been ignoring these red flags? I mean, COVID, obviously, a special case, but the pressure that they were under in order to get these hard-to-reach communities vaccinated.
I think the issue of pressure is a fact of life, and there always needs to be a degree of tension, but there is a point beyond which we shouldn't go, and this report shows that we went beyond that point. So,
Brian, can I ask, you've mentioned democratic processes and concerns about electoral integrity. The election result in this particular electorate was very close. Does a question or a shadow now hang over that result?
we don't have jurisdiction over that, which is why we've referred it to the Electoral Commission. They will need to look at that. My jurisdiction is the government agencies, and I will use every power that I have to make sure that they set a standard that New Zealanders can have confidence in.
The Electoral Commission has kind of got off scot-free in all this. No one's investigating the Electoral Commission. They've even said that Select Committee last year that they shouldn't have used the Morai as a polling booth. What's in place now to ensure that they're doing their jobs and the public can have confidence in that agency and the way that it performs its duties?
There's a lot of work going on to make sure that these questions do not ever rise again.
Can I ask what, if any conversation...
Specifically with the Electoral Commission?
Just with the Electoral Commission. I mean, the issues around the election are the legislative jurisdiction of someone else who's not in this room. I understand your question. I would encourage you to put it directly to them, because I don't have the knowledge or the jurisdiction to give you the confidence that you need.
Okay, so maybe a better question is, do you think Parliament should be investigating or should ask for an inquiry into the Electoral Commission?
That's entirely a matter for Parliament.
Can I ask what, if any, conversations were had with Te Pāti Māori throughout this inquiry and investigation?
Well, Te Pāti Māori were represented and had counsel and were given the drafts and commented on them, and those comments were considered.
How would you characterisation the cooperation levels from the third-party providers?
Do you want me to?
Yeah.
All of them cooperated. As you'll see in the report, Manarewa Marae met with us. We interviewed relevant people. In the case of Te Pou Matakana and Waipareira, they preferred to provide us information in writing through their lawyers.
Is that satisfactory to you?
Well, it was up to them, and either is fine.
Yeah. We got what we needed.
We got what we needed.
Why did it take so long to release this report?
It's a very complicated subject. It was worthy of making sure that we had our response. We were aware of what the findings were some time ago, and they have continued to be refined through Pania and Mike. But what I wanted to be able to do as the Public Service Commission is move from not just that we've got a problem here, but we have a number of interventions that are going to remedy it, and that work has been done and it will continue to be done.
The agencies provided some feedback, I believe, on your initial response. Did some of that involve pushback from the agencies?
I didn't. Mike or Pania, did they?
Are you asking in relation to the draft report or the response?
More with regards to the Public Service Commission. You asked them for some feedback?
I wasn't aware of that. I mean, there's normally a little bit of interpretation of things. We would normally, and as good process, we always check with affected parties what we're going to say. We're not obliged to take their feedback. I'm very comfortable with where we've got to.
There was no any pushback?
Nothing of any substance whatsoever. I mean, as I said earlier, a number of these things actually aren't up for debate. That is the way it has to be.
Given the increasing availability of very large anonymised data sets which tell us all sorts of things about different parts of society, and the extent to which it's now become as an observable fact that it's very difficult to reach certain parts of society with the census, and those are often parts of society where the census information will be of most use from a policy-making perspective. Is there a conversation yet happening, or you're aware of, that says, why do the census, particularly given these kinds of risks?
I think the last two census processes have been underwhelming in the view of some, and so there is a significant amount of conversation and work going on about actually what does census version 2 look like, because the need to maintain, good data sets and using them is a critical part of good decision making, but the way that we source that information, I think, has to change, and that's a matter that ministers will be deciding on in the next month or two, as I understand it.
During the vaccination campaign, particularly at the end of 2021, I believe it was, the Ministry of Health was taken to court and ordered to release Māori vaccination data to John Tamahere in particular. Did that court decision have any impact on the agencies and wanting to comply with that sort of direction from the court to hand over data?
Well, some aspects of your question are best answered by the agency and their decision making at the time, but what I can respond with is that the court decision required the Director General of Health to re-look at the decision, and so that's what the Director General did and made a decision to release a fuller range of data, and as we report, that happened over a period, I think, of October to December on a DHB by DHB basis.
Do you think a level of pressure there, because it was ordered by the court, maybe overrode some of those processes that may have been in place?
Well, that wasn't...
Okay.
that wasn't the question that we were asked to answer, but I think what we could see from the documents that we reviewed is that they had a court decision, they were requested to retake the decision that Ashley Bloomfield at that time had made, they retook the decision. And what resulted was that a wider set of data was released.
You mentioned that the head of Stats New Zealand, CEO of Stats New Zealand, or acting CEO of Stats NZ is not looking to have their contract renewed. If the CEO of Health New Zealand had not already indicated that they would be leaving that position, would it be your expectation that they would follow a similar path as Stats New Zealand?
Probably not, because I think, as the reviewers have pointed out, there were sort of issues there, but they didn't reach the threshold of what I believe to be a systemic failure within one agency, and that actually is what Stats have done here. So it's a threshold of seriousness.
Was there anybody else in Stats New Zealand that lost their jobs or resigned over this?
There were other people involved in this process who are no longer in employment, but they had left for different reasons, as I understand it.
With Mr. Soudan stepping down,
Yep.
are you setting a standard for accountability within the public service while you're the head of the Commission?
I'd like to think so.
And do you think that standard that you're setting is higher than what it's previously been?
I don't have a view on what it is in the past, but I think as we get into a new and different operating environment, there is a threshold, and this breached that threshold.
So you expect heads to roll, if people don't meet your expectations, they're gone?
Not in the punitive way that that's put.
Was Mr. Soudan nudged to resign, or did he see the report and go, writings on the wall here, or did you recommend that he not seek recommend?
We had a number of discussions. He reached a decision which, as I said earlier, I think is the right decision, and it's one that I respect.
Did you encourage him to
by himself, or would you encourage him?
Look, I'm not going to go into the details of an employment matter, but I think we've reached the right outcome here, and I think it does send a signal that there is a threshold beyond which public servants have to actually be careful. And I think it's a really sad day, for anyone to be in this position, but the reality is we are in the position and we've got to find a way forward, and I'm confident that we've done that.
Just to build on
data,
and then we'll finish soon. Okay?
just on the health data, again, at a high level, to what degree is this high trust model that was undertaken by Te Whatuora and Health NZ with their data sharing, the standard in how they share data with everyone versus, bespoke for these particular circumstances?
As I understand it, it is the standard method, and the transmission is secure. So to reiterate, we don't have concerns about the security of the transmission method. The concern we have is about the controls that don't operate over the data once it's received at the other end. And so as we understand it, sorry, just to go further, the DHBs, when they existed, primary health organisations, this is just the standard way that data is transferred from the centre to providers.
And so this line that pops up a few times, that Te Whatuora is working to revise its standard terms and adding audit, retention and disposal provisions. We can kind of assume that most existing health data sharing agreements have no audit, retention or disposable provisions in them.
That's one of the factors that we're looking to refresh and clarify from 1 July. I mean, the reality is there are a number of contracts in place. This, as I said earlier, this has highlighted some inadequacies in our current approach in contracts, and that is what we're going to remedy. We will be accused potentially of being bureaucratic. We're not being bureaucratic. We are saying there are minimum standards that apply to the use of public funds. If you receive public funds, there's a duty of care to the taxpayer, and we have to enforce that through contract.
It's quite shocking, though, isn't it, that this goes beyond just the COVID vaccination campaign, beyond Whanaora Commissioning Agency. If Te Whatuora has sent your data somewhere, it has no way of going and looking and making sure that it's been used correctly. For most people, that would be true, right?
I'm not sure whether that's true for most people, but it has happened as identified in this report, and that's what we're focused on remedying.
Can I just ask back about
that you've had to make to other, with the number of referrals that you've had to make to other agencies to investigate further, or are there enough legal and regulatory teeth in the system to deal with an issue like this arising again?
I think so.
Do you want more power?
I don't think I need any more power. I just think we need to exercise the powers that we've got in a focused way, and that's what we're trying to represent. We can and we will intervene with government agencies when we need to, and this was a need case.
You're currently in the process of having for lack of a better term, a look at the public sector. The Prime Minister this morning said that scope of that was potentially within the realms of shrinking it somewhat. How does this investigation, these findings, and the report in general play on your moves within the public sector to sort of redefine it and give it, a spruce up?
It doesn't contribute directly to it. at all. I mean, those issues and those comments are in the context of questions that I have posed to the chief executives about where we could make changes. You know, the issue is being picked up about structure. That's just work that we are going through. These issues do not directly impact on it one way or the other than to reinforce the Commission's role to set standards that others have to follow.
And I won't be able to name them all because I think there are a few, but there are a number of other different avenues that this goes to next. I mean, you mentioned the Privacy Commission, you mentioned police, there's probably about 14 others. Could you tell me from your perspective what happens next from you and the Public Service Commission?
For us, our focus, as I said, is on the public sector entities who are engaging with third parties and having contracts for service. That's where my focus is, and that's my jurisdiction. What the police are doing in terms of their investigation is a matter that you should put directly to them. I'm very confident that the work that we have done to date to refresh and reorientate our contracts is good work, and it will help protect us in the future from any allegations that we're currently being exposed to.
Some people might look at what's happened today and the extent of the failure within the public service sector here, and seeing essentially one chief executive who was going to resign anyway is the only one to cop any sort of repercussions from this. People might look at this and say this is a slap with a wet bus ticket. What would be your response to that?
I would reject that. I do not believe that to be true, and I do not believe that statement to be fair.
Can I ask just back about Manilewa Moai, why do you believe that those workers did not receive adequate privacy or confidentiality training?
Mike? Let me answer that. Well, it was a difference in attitude between Te Pou Matakana and Stats as to who was doing it and what it was to be delivered. And there was a train the trainers approach taken by Te Pou Matakana, and that wasn't at a level that Stats normally do.
So each believes that the other was doing the training, and the reality was that no one was doing it?
Not quite that, but they had different viewpoints on what training was required, and in the end there wasn't adequate training.
Which reinforces the point of the new standards. We need to be really clear where accountability is, so this I thought, you thought, that we don't get into that, because what we're dealing with deserves better.
We only have time for a couple more, guys.
A previous Stats New Zealand press release, I think from the end of last year, referenced Serious Fraud Office as one of the agencies involved. Are you aware of them investigating? Have you heard any matters?
I'm not aware of that. To my reviewers?
Well, they're a government agency, obviously, that looks at serious and complex fraud, and along the way one would expect the police to be talking to them about jurisdiction, but we're not actively engaged in that respect.
Were any allegations of fraud raised with the inquiry?
Raised.
Not really?
No. Of course, there's discussions around all sorts of jurisdiction, as you'll see from the terms of reference. The police, there are carve-outs in respect of police.
So did someone allege fraud was undertaken in the course of you doing your inquiry?
Not as specific as that, no. But the whistleblowers made allegations. You can find those publicly, and some of those could be interpreted as fraud. So, I guess, to be complete.
But we are not at this point. There is no investigation for fraud. So the matters which have been investigated are jurisdictions of ours. Graham?
One more?
No? Okay. Well, look, thank you. Graham's available for any follow-up questions or thoughts you may have or wish to put to us. But I do appreciate the time and apologise it's so stuffy in here. Thank you.
Thank you.